The Supreme Court will be taking up a gun rights case.
The court will consider whether people who use marijuana can legally own guns.
And this comes after a request from the Trump administration asking the high court to limit the right of drug users.
It's a case that legal experts will be watching closely when it likely heads before the justices.
Major news just dropped from the United States Supreme Court that every gun owner needs to understand immediately. The court has agreed to hear its Second Amendment case this term, and we're only in the early weeks of the session. This new case tackles a question that cuts to the heart of who can and cannot possess firearms under federal law, specifically whether the government can constitutionally ban gun ownership for anyone who uses or is addicted to controlled substances. The implications stretch far beyond this individual case and could fundamentally reshape how courts analyze firearm restrictions going forward. What makes this particularly significant isn't just the question being asked, but the defendant whose case is being used as the vehicle, and why that matters more than most people realize. Let me break down what's actually happening here, why the Second Amendment is almost certainly going to lose this particular battle, and most importantly, why how we lose might matter more than the loss itself. The Supreme Court has just granted certiorari, meaning they've agreed to hear arguments in another Second Amendment case for this term. They had already granted cert in the Woolford case from the Ninth Circuit, which deals with what critics call the vampire rule or the no-carry default rule that restricts where firearms can be carried. Now, breaking just today, the court has agreed to hear an additional case, Daniel Hammani versus United States. The question presented is whether federal statute 18 U.S.C. 922G3, which prohibits firearm possession by any person who is an unlawful user of or addicted to any controlled substance, is consistent with the Second Amendment's right to keep and bear arms. Let me cut directly to the uncomfortable reality that needs to be stated plainly. The Second Amendment is going to lose this case. That's not pessimism or defeatism. It's an assessment of the political and legal reality. There is zero chance this Supreme Court is going to rule that people who regularly use drugs, whether cocaine, heroin, marijuana, or any other controlled substance, can possess firearms without restriction. This court will find 5 votes, probably more, to say that if you're a regular user of these substances or you're addicted to them, the government can constitutionally disarm you consistent with the Second Amendment. That will be the outcome. It's essentially guaranteed. So if the outcome is predetermined, what's actually at stake that gun rights advocates should care about? The answer is methodology, how the court reaches that conclusion, and what legal framework they use to get there. That matters enormously because the reasoning established in this case will be applied to countless other gun control challenges going forward. There are 2 critically important components to every Supreme Court decision. First, obviously, is who wins the case. But the second component, which is often more important in the long run, is how the winning party prevails. The rationale, the legal reasoning, the analytical framework the court applies. In this case, that's all Second Amendment supporters should be focused on, because the methodology the Supreme Court uses to analyze this case under the Bruen standard will become precedent that we'll have to live with in every subsequent gun control challenge. Before diving into how this case will likely be decided, it's important to understand why many Second Amendment advocates are uncomfortable with the fact that the Department of Justice actively sought certiorari here. There's a strategic calculation that appears to be driving DOJ's approach, and it's not entirely unreasonable, even if it's potentially risky. This Department of Justice seems to operate from a clear worldview. If you're a law-abiding American who isn't a criminal, you should have full Second Amendment rights in all respects, and they'll defend those rights vigorously. On the other hand, this administration doesn't have sympathy for criminals. This is explicitly a law and order administration that supports police over criminals and isn't going to treat violent offenders with kid gloves. From a strategic perspective, there's actually logic to this approach. The strongest arguments against the Second Amendment and in favor of gun control invariably arise when criminals are on the streets engaging in psychopathic, violent behavior while misusing firearms. When someone shoots up a school, when a criminal uses guns to kill innocent people, these tragedies generate enormous public pressure for more restrictive gun control laws. So the Second Amendment community has a vested interest in not championing violent criminals or dangerous mentally ill individuals as poster children for gun rights. If dangerous people are incarcerated and off the streets, they can't commit the kinds of atrocities that fuel calls for restrictive gun legislation. It's not crazy for an administration to want to fully support Second Amendment rights for law-abiding citizens while simultaneously being tough on crime. That's philosophically consistent with a vision of ordered liberty, maximum freedom within a framework of reasonable rules that everyone must follow. The concern, however, is how the Supreme Court will rationalize upholding this gun control law under the Bruen methodology. The Bruen decision established a two-step framework. First, the text of the Second Amendment is examined to see if the regulated conduct falls within its scope. Second, if it does, the burden shifts to the government to demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. The worry is that when the Supreme Court finds this law constitutional, which they will, they might loosen the Bruen standards in ways that make it easier for anti-gun governments to justify modern gun control laws that should be unconstitutional. That's not a certainty, but it's a legitimate concern that needs monitoring. Now let's examine the facts surrounding Mr. Hammani, because understanding who the defendant is reveals exactly why this case is problematic as a vehicle for Second Amendment litigation. There are generally two types of cases that reach the Supreme Court involving the Second Amendment. First are civil cases brought by people like Dick Heller, upstanding, law-abiding Americans whose rights are being violated. Heller was allowed to carry his firearm during the day as part of his job in Washington, D.C., but was denied the ability to keep a handgun at home for self-defense. That's the fact pattern you want in front of the Supreme Court every time. Sympathetic plaintiffs who are clearly having their constitutional rights infringed. What you don't want is another Zaki Rahimi going before the Supreme Court with a defendant who is, to put it bluntly, a violent scumbag. Rahimi admitted under oath to taking his girlfriend's head and bashing it against a dashboard, then shooting at witnesses, then acknowledging he was a danger to society. That's exactly the kind of fact pattern that anti-gun advocates like Merrick Garland want presented to the Supreme Court, because it makes defending gun rights look like defending dangerous criminals. So where does Daniel Hammani fall on that spectrum? According to the Department of Justice's indictment, Hammani is a dual citizen of the United States and Pakistan. His actions drew FBI attention when a 2019 border search of his phone revealed communications suggesting he was prepared to commit fraud at the direction of suspected affiliates of the Iranian Revolutionary Guard Corps, a designated foreign terrorist organization. So we're now arguing a Second Amendment case before the Supreme Court on behalf of someone who is a Pakistani citizen with alleged connections to a designated terrorist organization. That's not the sympathetic plaintiff you want representing gun rights before the nation's highest court. It gets worse. Hammani and his parents traveled to Iran in 2020 to participate in celebrations honoring Qasem Soleimani, the Iranian general who was killed by American drone strikes. Again, this is not remotely the poster child you want for a Second Amendment case. Beyond these alarming associations, Hammani was also a drug dealer who used illegal drugs including marijuana and cocaine, and he admitted to all of this. So the defendant is a cocaine and marijuana user, a drug dealer with alleged affiliations to designated terrorist organizations, a Pakistani citizen, and he was found in possession of firearms. He was charged under 18 U.S.C. 922G3 for possessing firearms while being an unlawful user of or addicted to controlled substances. A federal appellate court threw out his conviction on grounds that there's no historical tradition supporting disarming people who use drugs. The Department of Justice requested Supreme Court review, and the court granted certiorari, which was predictable because there's a circuit split on this question, and when the Solicitor General requests review of a federal statute where circuits disagree, the Supreme Court grants certiorari approximately 99% of the time. The argument could be made that this won't be a disastrous loss because the court can rule narrowly by simply pointing to Rahimi and extending that reasoning. In Rahimi, the Supreme Court upheld restrictions on firearm possession for people subject to domestic violence restraining orders, relying on historical surety laws and affray laws from the founding era. Surety laws allowed courts that found someone dangerous to require them to post bond to keep the peace, essentially a financial guarantee of good behavior. Affray laws criminalized terrorizing people in public with weapons. The court said if someone is found by a court to be a violent danger to others, they can be temporarily disarmed while they remain dangerous. The Supreme Court will likely say something similar here. If you're arrested with a gun while you are an unlawful user of or addicted to controlled substances as defined by Congress, substances like marijuana, cocaine, heroin, or others, Congress has made a determination based on evidence that using these drugs makes you dangerous to yourself or others. The court will probably reason that if founding-era surety laws allowed temporary disarmament of dangerous individuals based on court findings and affray laws criminalized public weapons-based terrorization, Congress can take a middle ground, disarming you while you are actively using or addicted to these substances. The key will be the temporal limitation. If you stop being an unlawful user today, if you're no longer addicted today, tomorrow you can legally possess firearms again. The court might also reference that at the founding era, it was understood that lunatics and idiots could be disarmed. Lunatics were essentially people who were dangerously mentally ill, dangerous to themselves or others. Idiots was the founding era term for people who were cognitively disabled. The court could blend these historical examples with surety and affray laws to conclude that if you're currently using these drugs illegally or currently addicted to scheduled substances, you can't possess firearms during that temporary period. That's likely the framework we're going to see. The strategic concern isn't that the Department of Justice is necessarily making a mistake, but rather that there are other, better Second Amendment cases that could be prioritized. Cases with sympathetic plaintiffs whose rights are clearly being violated, rather than cases where the Second Amendment loses with bad facts. The balancing act the DOJ is attempting makes sense. They want law-abiding Americans to have full gun rights, but they also want criminals imprisoned because those criminals commit the acts that generate public support for gun control. The logic is understandable, but pushing these drug-related prohibition cases to the Supreme Court this quickly might not have been the optimal strategy. Time will reveal whether this approach works out or creates problematic precedent. The case isn't without risk, even if the likely outcome is manageable. What matters most is that the court doesn't use this case to significantly weaken the Bruen standard in ways that make all gun control laws easier to uphold going forward. If they rule narrowly, saying only that current active users of dangerous substances can be temporarily disarmed consistent with founding-era dangerous person laws, that's survivable. If they use this case to water down historical analysis requirements across the board, that's a different and far more concerning outcome. The answer will come when the court issues its decision later this term.